Where there is a will, there is probate. A will is a document made during your life. And what it does is it takes assets that you have, personal belongings that you have, and it permits you to say, upon my passing, I'd like to give the sum of $500 to this person. I'd like the property that I own to go to that person. However, when you're alive, you can dispose of your asset. But when you have passed away, anything that you own in your name is fixed, frozen in time in your name. And to be graphic, your deceased corpse cannot write, you can't sign a deed. I could say this because we're all alive and well. However, the will needs to be probated. It's not a self-executing document. You have to take the will and you have to probate it. You have to take the will and bring it to the surrogate's court and then follow all the rules and regulations and law of the EPTL, Estates Probate Trust Law, and the Surrogate's Court Act. And you have to listen to the surrogate. The surrogate is the judge, the surrogate's court. Each county either has one or two, and then the cases related to 4 broad areas of probate get handled. There's probate, administration, accounting, and miscellaneous. So depending on what you have, where you have, what you have to take care of. That's about it. Where there's a will, there's a probate. Will, probate. Can you avoid probate? Sure, you can give away everything during your life. You can do beneficiary designations on certain assets, and or you can do a trust, and a trust might be the way to go. Think about it. Learn. Look at my channel. What is a probate? What is an administration? Well, if a person passes away having a will, the process of taking that will, filing a petition, bringing it to court, validating the will, that process is called probate. If a person passes away without a will and a family member requires the assistance of the court, the process to get any of the assets of that person administered is called an administration. They're cousins. Probate with a will, administration without a will. In New York, we call the court that handles both matters the surrogate's court. Other states call it probate court. Some other states also call it surrogate's court. Now, with a will, without a will, there's a process that takes a number of months. You need to take, to submit a petition. The petition has certain legal information, right? Name, address, pedigree information, family tree, next of kin, amount of assets, a number of things in a several page document. Along with that, you have to submit a death certificate. In New York, you have to submit a paid funeral bill. I guess all of the funeral directors got together and lobbied the government. Well, actually, there's probably a very good reason. They don't want people to not have funeral services. So funeral directors will take the body, even provide a funeral service, and have a lien against the estate. And that can be satisfied by an insurance policy or by perhaps accessing other assets. That's why you go to surrogate's court. You're required to show a paid in full funeral bill to make sure that good grace is the funeral home treaded upon. So that's what an administration and a probate is and are. You only need to go through those procedures. If a person passes away with assets in their individual name, a house, a bank account, a brokerage account, you wouldn't need to go through either process to secure an insurance policy or to access a joint bank account or a joint property. You might need to do this if you had an insurance policy and your beneficiary, the person that was going to receive the death benefit, if that person predeceased, the deceased person, in this case, the dead people. In any event, we help the living take care of the dead. That sounds awful. We help the ones that are living to take care of the circumstances that involved their loved one. If you need any help, FrankBrunoLaw.com.